Good day everyone. In this video, we will discuss the general provisions under the Article 1636 to 1637, as well as the Republic Act Number 1157, also known as the Personal Property Security Act. Let's begin with Article 1636. First, we will discuss the purpose of Article 1636. Article 1636 provides the legal definition used in sales of goods. These definitions are important. Why? Because they clarify the meaning of key terms commonly used in commercial transactions. Second, it ensures the uniform interpretation of these terms. This means that all parties involved in the contract understand the same meaning, which helps to prevent the confusion and disputes. And lastly, it is a applied in contract involving the goods and documents of title. These documents represent the ownership or control over the goods and are the essential in a business transaction. Now, let's move on to the concept of documents of title to goods and goods under the Article 1636. First, the document of title to goods refers to a written instrument such as a bill of lading, warehouse receipt, key deed, dock warrant, and similar documents. These documents are important. Why? Because they represent the right to possess or control a goods. In simple terms, whoever owns the document is entitled to claim or transfer the goods. On the other hand, goods refers to a personal property or chattels personal. This includes the movable tangible items, as well as the crops or fruits that are still attached to the land but are meant to be harvested. However, goods do not include a money and things in action. Let's now proceed to the key legal terms and conditions found in Article 1636. These terms are essential in understanding how contracts of sales operate and how obligations between buyers and sellers are interpreted under the law. Let's start with other legal terms. First, order. Order refers to a transfer of ownership or rights through the endorsement of documents. This is commonly used in negotiable documents of title, where ownership can pass from one person to another simply by signing and delivering the goods. Next, the quality of goods. Quality of goods refers to a condition or state of the goods. Includes the factors such as a durability, functionality, and whether the goods meet the standards agreed upon the parties in a contract. Then, we have the specific goods. Specific goods are the goods that are clearly identified and agreed upon at the time the contract of sales is made. Lastly, we have value. Value in legal term is not limited to money. It also includes pre-existing debts or claims that can be used as payment or security. This means value can still exist even without cash, as long as something of legal worth is exchanged. After discussing the other legal terms, let us now proceed to a legal condition under the Article 1636. First is insolvency. Insolvency is the situation where the person is unable to pay their debts as they become due, or when they stop paying debts in the ordinary course of a business. This is important in sales transaction. Why? Because it affects the right of a seller, especially when the goods already been delivered but the payment has not yet been made. Next, we have the deliverable state. Deliverable state refers to a goods that are ready for deliver and acceptance by the buyer. This means that goods are complete in a proper condition and exactly as agreed upon the contract. The buyer should be able to receive them without any further work or adjustment. Now, we will proceed to Article 1637. Let us now look at the coverage of Article 1637. This provision states that contracts involving immovable properties are subject to mortgage law and the land of registration law. So, while the civil codes provide the general rules on sales, this special law must also be followed when dealing with lands or buildings. This applies specifically on the immovable properties such as land, buildings, and other things attached to the ground. This ensures that real properties transactions are properly regulated under a more specified legal frameworks. Next, let us discuss the applicable special laws. First, the mortgage law. This law governs mortgages over a real property. It provides the rules when a land or buildings are used as security for a loan. If a borrower fails to pay, the creditor has the right to enforce the mortgage and recover the obligation through the property. It also ensures that mortgage agreements are properly executed and legally recognized, protecting both the creditors and the debtor. Next is the Land Registration Law. This law governs the registration of the ownership over a real property. It establishes the system for officially recording land ownership. giving a legal recognition to the rightful owner. Through registration, ownership becomes more secure, binding, and protected against the third parties. It also helps prevent disputes and ensure stability in land transactions. Now, let us move on to the legal effects and importance of Article 1637. In the terms of legal effects, Article 1637 provides that the rules under the Civil Code apply only when they are consistent with special laws. In case of conflicts, the mortgage law and the land registration law will prevail since they are specifically govern real property transactions. In terms of importance, this provision prevents conflict between a general and special laws. It ensures that a correct legal framework is applied in real property transactions. It also protects ownership rights through proper registration and mortgage procedure, and promotes order, security, and reliability in a dealing land. And that concludes our discussion on Article 1637. Now that we have discussed the general provision under the Articles 1636 to 1637, we will move on to the overview of Republic Act No. 11057, also known as the Personal Property Security Act. Republic Act No. 11057 is an important law in the Philippines that governs secured transactions involving the personal properties. It focuses on the improving how assets such as equipment, inventory, and receivables can be used as collateral to obtain credit. Let us begin with the purpose of the law. The Personal Property Security Act, or the PPSA, was created to modernize secure transaction in the Philippines. Before this law, the system for using personal property as collateral was fragmented and outdated, making it difficult and complicated to access credit. With this law, the process becomes more simpler and standardized, making it easier for individuals and businesses to obtain financing. It also improves access to credit, especially to micro, small, and medium enterprises, which often do not have a real property to use as collateral. Also, this law provides a clear and unified legal framework that strengthens the protection of both lenders and borrowers by clearly defining their rights and obligations. So overall, it promotes the economic growth and financing stability by encouraging lending and investment. After discussing the overview, we will now proceed to Section 1, which is covered the title of Republic Act No. 11057. Section 1 states that the law shall be known as the Personal Property Security Act. This is the official name used to identify the law in all legal matters. It looks simple, but this section is important because it provides a clear and uniform way of referring to the law. By having one official title, it avoids confusion and ensures that everyone's like lawyers, businesses, and courts are talking about the same law. Now, let's explain the Section 2 Declaration of Policy. Section 2 tells us the main goal of the law. It explains why Republic Act No. 11057 was created. The law aims to make it easier for people, especially small businesses, owners, or MSMEs, to get loans. Many of them do not have a land or buildings to use as collateral. So this law allows them to use personal property like equipment, inventory, or other assets instead. It also wants to promote economic activity by helping more people start and grow their businesses. Another goal is to provide access to a low-cost credit. Because the law protects the lenders, they become more confident in giving a loans, which can lead to a lower interest rates for borrowers. The law also focuses on creating a clear and modern system or secured transaction. This means for the rules are easier to understand, more organized, and fair for both lenders and borrowers. And that concludes our overview and initial sections of Republic Act No. 11057.
To fully understand the Personal Property Security Act, we first need to master its legal language. So Section 3 serves as the law's dictionary, providing us with 11 key definitions from letters A to K. So the first term is the commodity contract. So a commodity contract isn't just the physical good like a sack of rice. It is the legal right to buy or sell that good at a specific price in the future. So to count under this law, it must be traded on a formal regulated exchange. So it could be local or foreign through an official broker. And the next term is the control agreement. So this is the power of attorney for collateral. It is a document where the person borrowing money tells their bank or broker that if I fail to pay my loan, follow the lender's order to move my money or stock immediately. So you don't need to ask me for permission again. The next term is the grantor. The grantor is the party providing the safety net. This is usually the owner of the property being used as collateral. It can be the borrower themselves or a third party like a parent providing collateral for someone else. The next term is the non-intermediated securities. So these are the directly owned stocks. So unlike other stocks or unlike the stocks bought on an app where a broker holds them for you, these are the stocks where your name is written directly in the company's official list of owners or you hold a physical stock certificate. The next term is notice. So a notice is like a public status update. It is the digital form filed in the national database to tell the public that a piece of property is currently being used as collateral. It's the law's way of saying that this item is already taken, so don't buy it without checking. So next term is proceeds. So the proceeds are whatever the collateral turns into. So if you sell the item, the cash is the proceeds. If the item burns down, the insurance money is the proceeds. So the lender's claim automatically moves from original item to these new assets. The next term is purchase money security interest or PMSI. So a PMSI is a buy now pay later security. It is special claim created because the credit provided was the specific reason the borrower was able to buy the item. Because the lender or seller enabled the purchase, they get special priority over that specific asset. The next term is the registry. So the registry is like the public bulletin board for debts. So it is a single online system for the entire Philippines. Lenders use it to announce their claims so that the public can check if an item like a car or machine is already being used as collateral. The next term is the secured creditor. So the secured creditor is the lender with the safety net. They have the legal right to seize the collateral if the debt isn't paid. So the law also treats people who buy debts, receivables, or rent out items for a long time as secured creditors, so they can be protected by the registry. The next term is the security interest. This is like the legal grip on an asset and it is a property right that guarantees a debt will be settled. So even if you call your deal a deposit or a sale, if its real purpose is to provide a collateral for a loan, the law treats this as a security interest. So lastly, our final term is writing. In the modern world, writing does not require a paper and ink because digital documents like emails, electronic contracts are all legally valid writings under the PPSA. This makes registering and creating loans much easier. Now, let's move on to the Section 4 of the Article 11057. So, it states that the law covers all deals involving movable property like equipment, inventory, vehicles, or bank accounts and can be used as collateral. It follows the substance over form rule that if it functions as a security, this law applies. However, it excludes high-value transport like planes and large ships because they already have their own specialized laws and registries.
Hey everyone, today I will discuss Chapter 2 which is about creation of security interest. But first, let us define what a security interest is. It is the legal right of a lender or creditor over a borrower's property that is used as a collateral for a loan. If the borrower fails to pay, the lender may claim that property. So for Section 5, creation of a security interest, a security interest is created through a security agreement. This means there must be an agreement between the borrower and the lender, stating that certain property will serve as collateral. It may also involve future property. However, the security interest only starts once the borrower actually owns the property or has the right to use it as a collateral. And for Section 6, security agreement, the security agreement must be written and signed by the parties. It can be in one document or several documents, as long as these show their intention to create a security interest. The borrower, also called the grantor, may choose to have agreement and notices written in Filipino. This is important because written contracts clearly show the rights and responsibilities of both parties. Section 7, about description of collateral. The collateral must be described clearly enough so it can be identified. The description may be specific or general. And for Section 8, right proceeds and commingled funds in money. If the collateral is sold, the security interest may continue in the proceeds, meaning the money earned from selling it. If that money is mixed with other funds in a bank account, the lender may still claim the amount that can be traced. Then for Section 9, continuity of security interest. The security interest remains attached to the collateral even if it's sold, leased, exchanged, or transferred. unless the law or the parties allow otherwise. This prevents borrowers from avoiding payment by simply selling the collateral. And for the last section of Chapter 2, Section 10 Contractual Limitation on the Creation of a Security Interest, a borrower may still use accounts receivable as collateral, even if another contract says they cannot. Accounts receivable are money owed to a business by customers. Since these are valuable assets, they can help businesses get financing. Now let's move on to Chapter 3, Perfection of Security Interest. So after a security interest is created in Chapter 2, the next important step is perfection. Perfection basically means making the creditor's rights stronger and recognized not just between the borrower and lender, but also against other people and third parties. For Section 11, Perfection of Security Interest, a security interest is not fully protected just because it has been created. It must first be perfected. And perfection happens when, first, the secured interest has already been created, and second, the secured creditor has completed one of the required actions under Section 12. Once these conditions are met, the secured interest becomes effective not only between the borrower and lender, but also against third parties such as other creditors or buyers. Next, Section 12 about means of protection. Now, how do you actually protect a security interest? A secured interest can be perfected through different methods depending on the type of collateral. And these are, first, registration of a notice in the registry. Second, possession of the collateral by the secured creditor. And third, control of investment property and deposits accounts. For tangible or physical assets, perfection is usually done through registration or possession. And for financial assets like bank accounts or investment property, it is done through the registration or control. The method depends on the nature of the property involved. For Section 13, perfection by control. And now, let's zoom in on control, especially for bank accounts and investments. A creditor can gain control in three ways. First, if the bank or intermediary itself becomes the third party. Second, through a control agreement between the parties. And third, or by recording security interest in the official records for electronic securities. However, banks or intermediaries are not required to enter into a control agreement, even if requested. This means control is a strong form of perfection, but it depends on agreement and legal arrangements. And for Section 14 about perfection in proceeds, now what happens if the collateral is sold? When collateral is sold or disposed of, secured interest does not automatically disappear, but only if the proceeds are in the form of money, accounts receivable, negotiable instruments, and deposit accounts. Then the secured interest automatically continues and remains perfected. However, if the proceeds are in a different form, the secured interest must be perfected within 15 days after the grantor receives them. If not, it will not be perfected against third parties. This rule ensures that the creditor remains protected even if the original collateral changes form, as long as proper action is taken on time. Then for Section 15, change in means of perfection. Sometimes the way a secured interest is perfected may change. For example, from possession to registration. As long as there's no moment where it becomes unperfected, the protection continues. The key idea here is continuity of protection. As long as there's no gap where the secured interest is unperfected, the creditor's right remains protected. Lastly, for Section 6 about assignment of secured interest. What if the creditor transfers the rights to another creditor? When a secured creditor transfers a perfected secured interest to another party, this is called an assignment. An amendment notice may be registered to reflect this change so that the records are updated. This ensures transparency, so it is clear who currently holds the rights over the collateral.
Now let's tackle Chapter 4, which is the priority of security interest. Now let's begin with Section 17, which covers the priority rules. So the general rule under Section 17 explains how to determine priority when two or more properties have competing security interests or liens over the same collateral. It states that priority is based on the time a notice is registered or when security interest is perfected through other legally recognized methods. So what's important is to understand here that the order in which the agreements were originally made does not matter. This goes against the common belief that the creditor who entered into the contract first should automatically have priority. However, Section 17 takes a different approach. It promotes fairness, and transparency by prioritizing those who take the proper legal steps to protect their rights. We have the Section 18, which discusses priority for perfection by control or having direct power over the collateral. This section introduces a special method of perfecting a security interest through control instead of registration. So, perfection by control is commonly used for certain types of assets, such as deposit accounts, investment properties, and other similar financial assets. Under this rule, a security interest is perfected by control generally has priority over one perfected by other methods like registration. In other words, if two or more parties have claims over the same collateral, the party who has control over the asset is usually given the stronger and superior right. The reason behind this is simple. Control provides a higher level of security and certainty, while registration only gives a public notice of a claim. Control means that the secured party has direct authority over the asset, including the ability to manage, transfer, or restrict its use. Because of this stronger form of protection, the law gives preference to those who have control. The next is Section 19, which discusses priority for instruments and negotiable documents. This section applies to assets such as promissory notes, checks, warehouse receipts, where a security interest is usually perfected through possession or control. Under this rule, priority is given to the party who first obtains possession or control in good faith. This means that the person who physically holds or legally controls the document is preferred over others. So, the purpose of this rule is to protect the reliability and value of these documents in business transactions, since they are designed to be easily transferred and trusted. In effect, possession or control determines priority, not registration or the timing of earlier agreements. So, the party who first holds or controls the document, in accordance with the law, of course, will have the stronger and superior right. So the next, we have Section 20, which discusses priority and the right of retention by operation of the law. But first, let's understand what the right of retention means. So, the right of retention is the legal right of a person to keep possession of someone else's property until they are fully paid for the services or materials they provided. Under this rule, individuals such as repair shops, mechanics, tailors, or warehouse keepers who work on, improve, or preserve goods are allowed to retain possession of those goods until the payment is made. So, this right is legally recognized and may even take priority over an already perfected security interest in the same property. The purpose of this rule is to protect those who directly add value to the goods through their labor, skills, or materials. Since their work helps maintain or increase the value of the property, the law ensures that they are paid before other secured creditors. Next, we have now Section 21 on transferee exceptions, which is mainly about protecting buyers, but only under certain conditions. So first, let's imagine a piece of a movable property, like a car, gadget, or equipment that already has security interest attached to it. This means a creditor has a legal claim over it because it was used as collateral for a loan. Normally, the security interest follows the property, so even if the property is sold, the creditor can still enforce their right over it. However, Section 21 creates an exception to this rule. It states that if a person buys or receives the property in the ordinary course of business, meaning a normal transaction like buying from a store, and does so in good faith, meaning they honestly did not know about the security interest, then the buyer is protected. In this case, the buyer can keep the property free from the security interest and the creditor can no longer claim it. But there is an important limitation. If the security interest was already registered before the buyer acquired the property, then the buyer is no longer considered to be in good faith. This is because registration serves as public notice. So, the law assumes that buyers should check whether there are existing claims on the property before purchasing it. So, if the security interest is already registered, the buyer cannot claim ignorance, and the creditor's security interest will still apply. Section 21 balances fairness between innocent buyers and secured creditors, but it generally favors creditors when their security interest has been properly registered. Now, let's move on to Section 22, which explains the effect of the grantor's insolvency on the priority of a security interest. This section deals with what happens when the grantor becomes insolvent, meaning they are unable to pay their debts. This rule is straightforward. If a security interest was already perfected before the start of insolvency proceedings, it will remain perfected and will keep the same priority it had before insolvency. This means the creditor does not lose their legal protection or ranking simply because the debtor becomes insolvent. Their claim over the collateral remains valid and continues to have the same level of priority compared to other creditors. However, this rule is still subject to insolvency law, meaning there be specific procedures or limitations during insolvency proceedings that can affect enforcement, but generally, the secured creditor's priority is preserved. Moving on to Section 23, which discusses the Purchase Money Security Interest or PMSI. This section explains why PMSI is given special priority over security interest, but only if certain strict requirements are followed. A PMSI happens when a lender or seller provides money or credit specifically so the debtor can acquire a particular asset such as equipment, consumer goods, inventory, intellectual property, or livestock. Because the credit directly helps the debtor acquire the property, the law gives the PMSI creditor a stronger priority, but only if the required rules are followed. To better understand this section, it is divided into subsections depending on the type of property involved and the conditions required. So for equipment, the first, PMSI creditor gets priority over other security interests as long as they register the notice within 3 business days after the debtor receives the equipment. Even if another creditor already has security interest, the PMSI creditor will still have the priority as long as registration is done on time. So the next is consumer goods. For consumer goods, which are items used for personal purposes, a PMSI also has priority over other security interests as long as the notice is registered within 3 business days after the buyer receives the goods. Again, the key requirement here is timely registration. So the next one is inventory, intellectual property, and livestock. For inventory, intellectual property, and livestock, the rules are stricter because these assets are commonly used in business and are frequently sold or transferred. A PMSI will only have priority if the PMSI is already perfected when the debtor receives the goods or rights and before the debtor receives them. The PMSI creditor gives written notice to existing secured creditors who already have claims over the same type of assets. This notice informs other creditors in advance and may also cover multiple transactions. Protection against other claimants. If a PMSI in equipment or consumer goods is properly and timely perfected, it can also have priority over buyers, lessees, and lien holders, but only for claims that arise after the goods are delivered but before the PMSI is registered. So even if other parties try to claim the property during that period, the PMSI creditor is still protected as long as all legal requirements are followed. Next is Section 24, which discusses livestock. This section gives special protection to a creditor who helps a livestock owner pay for the essential needs of the animal, specifically food and medicine. Let's put it in simple terms. Imagine a farmer owns a cattle but does not have enough money to buy feed or medicine. A lender steps in and provides credit so the farmer can purchase those essentials, because that loan directly helps the livestock alive and maintains their value. The law gives that lender a special priority right over other creditors who also have claims on the same livestock. However, this priority is not automatic. The lender must first give written notice to other creditors who already have registered claim over the livestock before the food or medicine is delivered. This ensures that existing creditors are informed that another party is financing the upkeep of the animals. But there is an important exception. If another creditor holds a purchase money security interest in the livestock, that PMSI creditor will have the higher priority. This is because PMSI is generally considered the strongest type of security interest as it financed the acquisition of the property itself. Lastly, we have Section 25, which discusses fixture, accessions, and commingled goods. This section explains what happens to a security interest when the property changes form, becomes combined with other property. First, it covers 3 situations. Fixtures, when a movable property is attached to land or a building, such as an air conditioning unit or machinery installed in a factory. Accession, when one thing becomes part of another, such as parts added to improve or complete a product. Commingling, when goods are mixed together in a way that they can no longer be easily separated, such as grains or oil stored together. Normally, one might assume that the security interest is lost once the property changes form or becomes mixed. However, Section 25 provides that the security interest continues as long as the original property can still be reasonably identified or traced. So, for example, if a machine is installed in a building and becomes a fixture, the creditor may still have a claim over that machine if it can still be clearly identified. However, if the goods are completely mixed and can no longer be separated or identified, the situation becomes more complex. While Section 25 protects the security interest issues involving ownership rights over fixtures, accessions, or commingled goods are ultimately governed by the Civil Code of the Philippines.
Good day everyone! First, let's understand what registration or registry means. This is not just a simple record book, it is an official electronic system where legal notices are stored. Instead of using paper, everything is done digitally, which make it faster and easier to access. It is managed by the Land Registration Authority or LRA, meaning they are responsible for maintaining and securing all the records. The main purpose of the system is to register and search security interests. A search security interest means a right over property used as collateral for a loan. For example, if someone borrows money and uses their motorcycle as collateral, that agreement can be recorded in the registry. This way, other people will know that the motorcycle is already tied to a loan. Lastly, it serves as a public legal record, meaning anyone can check it if needed. Now that we understand what the registry is. Next, let's discuss Section 26, Establishment of Electronic Registry. In this section, the law officially creates the registry system. It clearly says that the registry is established and administered by the Land Registration Authority. So, the LRA has full control and responsibility over it. The registry provides an electronic system mainly for two things. First is the registration of notices, which means entering or recording legal claims or interest. Second is the searching of notices, which allow people to check if a property already has an existing claim. For example, before accepting a car as collateral, a lender can search the registry to make sure it is not already used in another loan. So this system helps prevent fraud and protects both parties. Now that we know how the registry is established, let's discuss Section 27, Public Record. This section explains that all registered notices are considered public records. This means that any person can search the registry. It is not limited to lawyers or punks. Anyone with a valid reasons can access it. Also, the records stored electronically are considered official record, meaning they are legally recognized. Let's discuss Section 28, Sufficiency of Notice. This section is very important because it explains what makes a notice acceptable in the registry. The law says that a notice shall not be rejected as long as it contains the basic required information. This means that the system focuses more on completeness, not perfection. This includes, first is the grantor identification number. This is important because it is the main way to search records. If this is missing or wrong, the notice may not be found. Second is the secured creditor's name, to know who has the legal claim. Third is the complete addresses, so both parties can be identified and contacted if needed. Fourth is a clear description of the collateral. This avoids confusion about what property is involved. And last, payment of fees, because registration is an official process. Let's discuss Section 29, one notice sufficient for security interest under multiple security agreements. This section focuses on efficiency and convenience. Instead of filing many notices for different agreements, the law allows one notice to cover multiple security agreements. This reduces time, cost, and duplication of records. Next, let's discuss Section 30, Effectiveness of Notice. This section explains when a notice becomes legally effective. A notice is effective once it is recorded in the registry and searchable by the public. This means even if it is already submitted, it only becomes valid when others can actually find it in the system. The notice is also valid only for a certain period, so it does not last forever. This prevents outdated claims from staying active. It must also comply with the requirements, meaning it should not have major errors. If a notice is seriously misleading, like having incorrect or missing key details, it may become invalid. Let's discuss Section 31, Seriously Misleading Notice. This section focuses on serious errors in a notice. A notice is considered seriously misleading if it fails to properly identify the grantor. Why is this important? Because the registry system mainly depends on the grantor identification when searching. If that information is missing or incorrect, the notice cannot be found, and it is become invalid and ineffective. So this section emphasizes the accuracy in key details is critical. Let's discuss Section 32, Amendment of Notice. This section allows changes or updates to an existing notice. Instead of deleting and creating a new one, the system allows an amendment notice. This amendment must refer to the original notice and include the new one or corrected information. However, some changes require written consent, such as adding new collateral, adding a new grantor. This protects the parties from unauthorized changes. Let's discuss Section 33, Continuation of a Notice. These sections explain how to extend the life of a notice. Since notices expire after a certain time, the creditor must file a continuation notice to keep it active. This must be done within 6 months before expiration. So this section ensures that only active and relevant notices remain valid. Section 34, Termination of Effectiveness of a Notice. These sections explain how a notice is officially ended. A notice is terminated by filing a termination notice, which includes the original registration number and the creditor authorization. This usually happens when the obligation is already fully paid. Next, let's discuss Section 35, Registry Duties. These sections explain the role of the registry. The registry must assign a unique number to each notice, record the date and time, keep record accessible to the public, organize them properly for easy searching. For example, if someone searches using grantor's ID, the system should quickly show matching results. This also provides copies to the filer and keeps expired records for 10 years. However, the registry is only administrative, so meaning it does not check if the information is true. It only records it. This is important because responsibility still ties with the parties. Now that we understand the registry duties. Next, let's discuss Section 36, Search of Registry Records and Certified Report. This section highlights the importance of transparency and legal proof. Anyone can request a search, and the system will show all relevant notices. A certified report is very powerful because it serves as official evidence in the court. Now that we understand searching, next let's discuss Section 37, Disclosure of Information. This section ensures accountability of the creditor. They must disclose information when requested, especially about the remaining debt and collateral. This prevents hidden charges or unclear obligation. At the same time, it protects bank privacy, especially for deposit accounts. So this balances transparency and confidentiality. Next, let's discuss Section 38, Fees Set by Regulation. This section ensures that fees are fair and reasonable. Some services are free to encourage public access, especially searches. This promotes transparency without financial burden. Let's discuss Section 39, when the grantor may demand amendment or termination of notice. This section is important because it protects the right of the grantor or the borrower. It gives the grantor the power to demand correction or removal of a notice when it is no longer valid or accurate. The grantor may request amendment or termination if first is the obligation is fully paid, meaning there is no more debt. Second, part of the collateral has been released. Third is the listed collateral is incorrect or not included in the agreement. Fourth is there is no existing security agreement or the security interest is already extinguished or ended. Next, let's discuss Section 40. Matters that may be required by demand. This section explains the responsibility of the secured creditor after receiving a demand from the grantor. Once the creditor receives the request, they are given 15 working days to act. Within that period, they must file a termination if the obligation is fully paid. There is no valid agreement or the security interest is no longer exists. Or file amendment notice if some collateral is no longer included or incorrect information needs to be fixed. This section ensures that creditor act quickly and responsibly and that records stay accurate. Next, let's discuss Section 41. Procedure of non-compliance with demand. These sections explain what happens if the secured creditor fails or refuses to comply with the grantor's demand. If the creditor does not act within 15 working days, the grantor has the right to seek help from the court. The court can then order the termination of the notice or the amendment of the notice. Let's discuss Section 42. Compulsory amendment or termination by court order. This section highlights the authority of the court. If the court decides that a notice shall be amended or terminated, its decision is final and binding on the Land Registration Authority. This means the LRA must follow and update the registry as soon as possible. Even if the secured creditor disagrees, they must still comply, although they are allowed to appeal the decision. Let's discuss Section 43. No fee for compliance of demand. This section protects the grantor from unnecessary or unfair charges. It clearly states that the secured creditor cannot charge any fee when they are complying with a demand under Section 39. This section promotes fairness and prevents abuse. Let's discuss Section 44. When registration and search constitute inference with privacy of individual. This section focuses on the proper and lawful use of the registry. Even if the system is public, it must not be abused. The registry must not be used for, first is frivolous purposes, like unnecessary or meaningless searches. Second is malicious intent, like using information to harm someone. Third is criminal purposes, like fraud or illegal activities.
Good day, everyone. So now I'll be explaining Chapter 6, which is about the enforcement of security interests and the rights of a secured creditor. So now, let's first understand what is enforcement of security interest. In simple terms, this is just the process of how the creditor gets their money back if the debtor fails to pay. Section 45, Right of Redemption. This section gives the debtor a final chance to fix the situation. Even if they already failed to pay, they can still get their collateral back. But of course, there's a condition. They must pay the full amount of the debt, including any extra costs like legal fees or other expenses. So it's like giving the debtor one last opportunity to make things right and avoid losing their property. However, this right is only available for a limited time, so it must be done before the collateral is sold, disposed of, or kept by the creditor. Once that happens, or if the debtor already gave the right, then it's already final and they can no longer recover it. Section 46, Higher Ranking Secured Creditor. This section talks about priority. In a real situation, a debtor might owe money to more than one creditor, but not all creditors have equal rights. Some have higher priority, meaning they have a stronger claim over the collateral. You can imagine this like a line. Of course, those in front get served first. Because of this, a higher ranking creditor can step in and take over the enforcement process if needed. They can also intervene before the collateral is sold, specifically if their rights might be affected. This rule helps avoid confusion and ensures that the one with a stronger legal claim is properly protected. Section 47, Expedited Repossession. This section allows the creditor to take back the collateral without going to the court. But of course, there's a condition. It must be done peacefully. So this means that the creditor cannot use force, threats, or any kind of violence. For example, they cannot break into a property or intimidate the debtor just to get the collateral. If the situation becomes tense or the debtor resists, then the creditor must stop and go through the court process instead. So even if the creditor has the right to repossess, they are still required to act properly and respect the law. Section 48, Recovery in Special Cases. This section only means the creditor can still ask for other payment, not just the collateral. Basically, there are other ways to recover the debt. For example, if someone else owes money to the debtor, then the creditor can go directly to that person and collect the payment. They can also use funds from debtor's bank account, especially if there is already available money. In some cases, the creditor can even instruct the bank to transfer the funds directly to them. So instead of relying in just one method, the creditor has multiple options, which makes the process more flexible and practical. Section 50, Commercial Reasonableness. This section simply means that when the creditor sells the collateral, they must do it in a fair and proper way. They should follow normal business practices and not take advantage of the situation. For example, they should not rush the sale or hide important information. Even if the price ends up being low, it does not automatically means that the sale is unfair. What really matters is that the process itself was done honestly and reasonably. Section 49, Right to dispose of collateral. This is where the creditor can sell the collateral if the debtor still cannot pay. This can be done through a public sale, like an auction where anyone can participate, or through a private sale depending on the situation. The creditor can also buy the collateral, but only during a public sale. For private sale, it is only allowed if the item has a clear and known value in the market. This rule is important because it prevents unfair practices like selling the collateral secretly or selling it in an unreasonable price. Section 50, Commercial Reasonableness. This section simply means that when the creditor sells the collateral, they must do it in a fair and proper way. They should follow normal business practices and not take advantage of the situation. For example, they should not rush the sale or hide important information. Even if the price ends up being low, it does not automatically means that the sale is unfair. What really matters is that the process itself was done honestly and reasonably. Section 51, Notification of Disposition. This section means that before selling the collateral, the creditor must inform the people involved. This includes the debtor and other creditors. They must be given at least 10 days notice so they have time to prepare or respond if needed. The notice should also include important details like what will be sold, how it will be sold, and when and where it will happen. However, there are exceptions, such as when the item is perishable or quickly loses value. Also, the debtor can choose to waive this notice if they agree. Section 52, Distribution of Proceeds. After the collateral is sold, the money collected is distributed in a specific order. First, the expenses related to the sale are paid. These include costs for storing the collateral, handling, or even transporting it. These expenses must be settled before anyone receives payment. Next is the secured creditor is also paid. The secured creditor is the person that has a legal claim over the collateral because of the unpaid debt. After the secured creditor is paid, other creditors may also receive payment depending on their priority or legal rights. If there is still money left after all payments are completed, the remaining amount is returned to the debtor. However, if the money earned is not enough to fully pay the debt, the debtor is still responsible for paying the remaining balance. Section 53, Rights of Buyers and Third Parties. This section protects people who are not directly part of the debt. If someone buys the collateral properly, they are protected and do not have to worry about other claims. If another person is already using the property, such as renter or tenant, they are generally allowed to continue using it according to the terms of their agreement or contract. Also, even if there was an error or mistake during the process, the buyer can still be protected as long as they honestly did not know about the problem. This means that a buyer who acted in a good faith will usually keep their rights over the property. So this ensures fairness, not just for the creditor and the debtor, but also for the other people involved. Section 54, Retention of Collateral. Under this section, instead of selling the collateral, the creditor can choose to keep it. This can serve as payment for the debt, either full or partial. But before doing this, they must inform the debtor and other involved parties. If no one objects within 20 days, then it becomes final. If it is only partial payment, then everyone must agree in writing. This ensures that decision is fair and clearly accepted by all.
So let's now move on to Chapter 7, which is all about transitional provisions. So this explains what happens when a new law is introduced while an old system is still in place.
It acts like a bridge ensuring that the process is organized and fair by clarifying the status of existing rights, contracts, and cases during the transition. So starting with Section 55, it establishes the foundation for understanding how the law applies during the transition by clearly defining the key terms. So first we have is existing secured creditor. This refers to a lender with a loan secured by collateral before the new law took effect. Next we have is prior law. This simply means the old law previously in effect. And then we have prior interest. This refers to a security interest created under the old law that remains active. However, we should note that if an agreement is updated, renewed, or extended after the new law starts, then it is no longer considered prior and must already follow the new rules. And for the last term we have is transitional period. It is the adjustment phase from the law's effective date until the registry system is fully established and operational. Now, moving on to Section 56, it talks about prior interest or the agreements that were made before the new law took effect. So the main idea here is very simple. If an agreement was valid under the old law, then it remains valid now. The section says that the creation of this prior interest is based on the prior law. So whatever rules applied before are still used to check if the agreement is valid. But even if it doesn't meet the new legal requirements, it is still effective between the parties involved. So this means that the borrower is still required to pay and the lender still has the rights over the collateral. Next, we have a Section 57, which focuses on the concept of perfection. Or it simply means that the creditor's rights are protected not just between the borrower and the creditor, but also against other people who may claim the same asset. First, if an interest was already perfected under the old law, then it stays protected temporarily. It lasts until it either expires on its own or the transitional period ends. This section also says that if the creditor follows the new law's requirement before the old protection ends, then the protection continues without interruption. So there's no break in their rights. But if the creditor does not comply in time, there can be a gap in protection, and during that gap, the creditor may lose priority, meaning that the other creditors could have a stronger claim. Furthermore, the transition process is now made easier. The registration now only requires a written agreement, eliminating the need for additional approvals. And lastly, the original registration date remains effective, ensuring that the creditor's priority is preserved despite the change in law. So now, moving on to Section 58, it addresses priority, which simply means who has the better right or who gets paid first when multiple creditors claim the same collateral. So as a general rule, the old law still decides the ranking, provided that the claims existed before the change and nothing about them changed since. Now, if the situation stay the same, the original order stands. However, that ranking can shift. If a creditor's protection expires or if a new claim is perfected under the new law, then the new rules take over. For the last section for Chapter 7, we have Section 59. So Section 59 talks about what happens when a creditor is already enforcing a security interest before the new law takes effect. Now, if enforcement has already begun, like foreclosure or other collection actions, it does not stop just because there is a new law. The process can either continue under the old law or it may proceed under the new law, depending on what is applicable. This means that the law allows flexibility so that ongoing enforcement is not interrupted by the change in rules. However, we should note that there is one key exception. If a case was already filed in court before the new law started, then it must follow the old law until it is finished. This ensures that legal proceedings stay consistent from start to finish. Now, moving on to Chapter 8, this is all about how the law moves from paper to reality. It focuses on how the law is monitored, funded, and improved over time. So basically, this chapter ensures that the law isn't just a set of rules, but a working system with clear government responsibilities. Starting off with Section 60, to make sure that the law stays effective, Section 60 creates a Congressional Oversight Committee. This group, made up of members from the Senate and from the House, is required to review the law every 5 years. This is important because these are the people who understand the system and can properly evaluate if the law is working or if it needs to be updated. Now, moving on to Section 61, this part talks about what happens when there is a conflict between this act and another law. So first, the general rule is that this act will prevail. This means that if there is a conflict, the law we are discussing right now will be followed instead of any other law. However, there is one exception. If another law clearly and specifically states that it is amending or changing this act, then that other law will be followed. In other words, it's not enough for another law to just conflict. It must clearly say that it is modifying this act. And because of this, Section 61 helps avoid confusion and it gives a clear rule on which law applies, especially when different laws overlap. Now, Section 62 is about putting the law into action. Within 6 months of the law being passed, the Department of Finance and the Land Registration Authority must create the IRR or the Implementing Rules and Regulations. The IRR acts as the instruction manual for the law. While the Act itself provides for the general principles, the IRR breaks them down into clear, step-by-step procedures. And this ensures that everyone knows exactly how to follow the rules in real life. Next, we have a Section 63. This part talks about how cases under this law will be handled in court. According to this section, to keep up with the speed of business, the law mandates summary proceedings. These are the faster court processes compared to the usual long and complicated legal procedures. The goal of it is efficiency. Since the law aims to make transactions faster, the enforcement process must match that speed. And by using summary proceedings, parties can resolve disputes quickly, preventing long delays in financial or secure transactions. However, speed does not mean a lack of fairness. These proceedings must still follow the law's policy and the rules set by the Supreme Court. This ensures that while the process is fast and efficient, it remains organized, fair, and legally sound for everyone involved. A law is only effective if it is funded. Moving on to Section 64, it explains how the new law is funded. According to the section, instead of requesting a new budget from the national government, the funds will come from a special account of the Land Registration Authority, or the LRA. This account is built from the revenues the LRA already collects. And by using these existing resources, the law becomes self-sustaining. This is a major advantage because it avoids the typical delays of waiting for new funding approvals, making the implementation much faster and more efficient. The next section we have is Section 65. It addresses what happens if a specific part of the law is ever declared unconstitutional or invalid. So the rule here is that the law is severable. This means that if one provision is struck down by a court, the rest of the law remains valid and enforceable. The entire act isn't cancelled just because of a single issue in one section. This is vital for the law stability because it allows each section to stand on its own, so if a problem is found in one area, the remaining parts can still function properly. Now, moving on to Section 66, this part talks about what happens to old laws when the new law is in place. It says that any old rules or laws that don't match the new system will be repealed, updated, or changed. And instead of having a bunch of old, confusing laws that contradict each other, this section is trying to clean up the system, making sure that everything is consistent. And there are several specific laws that are affected by this change. And this includes parts of the chattel mortgage law, provisions in the Civil Code, the Financing Company Act, and even the Land Transportation and Traffic Code. So by repealing these old provisions, the system becomes much clearer. And instead of forcing businesses, creditors, and courts to navigate conflicting rules, Section 66 ensures there is only one organized and easy-to-follow standard. So second to the last, when does the new law actually start? According to Section 67, the new law officially takes effect 15 days after it is published in at least 2 national newspapers. This isn't just a random rule, it's about fairness. The government has to give the people official notice so they can learn about the new rules, and by publishing it in the papers, everyone gets a chance to see what's changing before the new law is actually enforced. Also, this is important because in law, ignorance is not an excuse. That's why publication is required, to make sure that everyone has the access to the information. Finally, we have Section 68. This part explains that even if the law is effective, we can fully use it until the registry system is actually ready. So even if the new law already takes effect under Section 67, its full implementation is still dependent on one important requirement, which is the registry system. This means that the law cannot be fully applied immediately if the system it relies on is not yet ready. This is important because the registry system is what makes the law work in real life, especially for recording and managing transactions. So without it, implementation would not be effective or organized.